appreciate that father of the nation wanted a federal state, and he wanted autonomy of the federating units. We are, my lords, interwoven in a very delicate and complex relationship. And what guarantees the autonomy of the federating units is the fact that there is a federal legislative list, there is no provincial legislative list, and the concurrent legislative list is gone. So anything which is neither in the federal legislative list nor in the substantive part of the Constitution is a provincial matter, my lord. So, if this honorable court gives the parliament the power to enact on a subject which may not be there in the federal legislative list or the substantive part of the Constitution, at the garb of item number 57 and 58, or at the garb of incidental and ancillary powers, it means that the parliament may encroach upon the provincial subjects.
पहले नेक्स्ट पॉइंट, ये तो आर्गुमेंट अजीब सा है, तो आपका कहना है कि 4 सूबे अपने अपने कानून बना सकते हैं?
ये नहीं है मेरा.
तो ये आप यही कह रहे हैं?
No, my lord, no, my lord. Residuary matters, there is no provincial legislative list.
हमें पता है ना, इस कानून की बात करें ना.
My lord, it has implications. It has implications, and these are not remote implications. These are immediate implications.
अगला पॉइंट बताएं.
So the submission is, the prime submission pertains to the legislative competence or the legislative incompetence of the federal legislature, my lord. My second submission is that, and it was pointed out by Honorable Justice Musarati Lali in the form of a question.
Please, direct argue करिए.
My lord, answers भी तो brief मैं time नहीं लूँगा. That apparently, by virtue of the act in question, the office of the Chief Justice has been done away with. It has been abolished for all practical purposes, my lords. And lordships would appreciate that as per definition given by Article 176.
Before you say this, first say which provisions of the Constitution create the office of the Chief Justice, which has been abolished.
My lord, 176 defines the Supreme Court, which says that the Supreme Court shall comprise of the Chief Justice and judges, as many judges as determined by the Parliament or Presidential Act. So the institution stands on 2 limbs, office of the Chief Justice and judges, my lord.
आपकी अगर ये बात मान ली जाए तो आप कहते हैं कि चीफ जस्टिस और जजेस अलग-अलग नहीं है, एक ही है.
My lord,
और अगर एक ही है तो फिर क्या चीफ जस्टिस अकेले रोस्टर बना सकता है?
My lord, रोस्टर बनाने से पहले मैं एक अर्ज कर लूँ, my lord. We hear that the Chief Justice is senior among equals. While sitting in the judicial capacity,
let's not go over.
Point
आप बताएं ना.
Point पे आ रहा हूँ, my lord. While sitting in judicial capacity, he is equal among the equals.
आगे बढ़िए.
What makes him senior among equals is administration. Now, what has been done through this?
There are certain powers specifically bestowed on the Chief Justice in the Constitution.
May I refer to them, my lord?
Yes, there's some powers have been specifically bestowed on the Chief Justice.
Thank you, my lord. I'm referring to them. Some of the powers, my lord. Article 183(2).
The specific mention is of Chief Justice.
Seat of the Supreme Court, Clause 2. The Supreme Court may from time to time sit in such other places as the Chief Justice of Pakistan, with the approval of the President, may appoint.
This is destructive of your argument. Here the Chief Justice has been given this power, not the Supreme Court.
Yes, my lord. Yes, my lord. Because it is at the administrative powers. It is the indication that the Chief Justice is the master of the rolls. He is a pater familias. This is the first indication.
ये लफ्ज इस्तेमाल हो रहे हैं, मगर ये आइन में नहीं है. केस लॉ में है.
आइन में यह है कि Chief Justice on his own, without any consultation, without any recommendation of the committee, shall appoint the place of sitting.
Correct.
Yes,
because
my
the
lord.
Constitution says so.
So administratively, the Chief Justice has at least some say. While the Impugned Act, मैं दूसरे provision पे आता हूँ, my lord.
बेंचेस के हवाले से वकील साहब विद द अप्रूवल ऑफ प्रेसिडेंट
Yes.
सर्किट बनते हैं ना
Yes,
ये
yes.
उसके हवाले से
हाँ.
और ये कॉन्स्टिट्यूशनल प्रोविजन है इसके लिए रूल की जरूरत नहीं
Yes, my lord. No
ठीक है
rule.
ना?
No rule is required.
इसका
But
नोटिफिकेशन होता है
yes, my lord. Yes, my lord. But under the Constitution.
इस सिलसिले में नहीं है जो आप बात कर रहे हैं
तो
Yes,
बेंच
ma'am.
बनाने का पावर है बेंच का पावर विद द अप्रूवल ऑफ प्रेसिडेंट होगा
With the
और
approval
उसके
of-
लिए रूल तो वही अप्लाई होंगे जो ऑलरेडी पहले से रूल इन फोर्स है ठीक है ना
Exactly, my lord, exactly. But now, Article 10, Clause 1, Roman 1, Federal Review Board. Article 10, 10, 1, Roman 1, after the explanation in the bottom.
आर्टिकल 10 का
जी हाँ, चीफ जस्टिस का जिक्र है.
In the case of a person, is that before your lordship? In the case of a person detained under a federal law, a board appointed by the Chief Justice Pakistan and consisting of a chairman and two other persons, each of whom is or has been a judge of the Supreme Court or a High Court. Now, for all practical purposes, this is a bench to be constituted by the Chief Justice of Pakistan, my lord.
This is not bench of the Supreme Court. This is not a bench of the Supreme Court.
Not stricto sensu.
Tribunal.
But a forum is appointed by the Chief Justice.
We are
Mere
talking
point,
about the bench constitution, composition of the benches of the Supreme Court.
मैं एक अर्ज कर रहा हूँ जो पॉइंट मैं बता रहा हूँ वो ये है कि अंडर द कॉन्स्टिट्यूशन इन द एडमिनिस्ट्रेटिव मैटर्स द चीफ जस्टिस इज ऑन द ड्राइविंग सीट. नाउ आई एम रेफरिंग टू आर्टिकल 146(3), 152, 159,
146.
clause 3. This is only for reference. I'm not reading, my lord. 146(3),
जी
152 and 159 clause 4.
152.
152 and 159 clause 4. Under these provisions,
152 or 150.
9(4).
जी.
Under these provisions of the Constitution, the Chief Justice is empowered to appoint an arbitrator in certain fiscal matters, in certain disputes, my lord. Now, under the original Constitution, prior to the 22nd Amendment, the Chief Justice was empowered to appoint a caretaker, Chief Election Commissioner out of the judges of the Supreme Court. Under the original Constitution, prior to the 17th and 18th Amendment, the Chief Justice alone acted as a consultee for appointments in the judicial.
What is the point you're making?
My point is, my lord, that when we say that the Chief Justice is senior among equals, what distinguishes the Chief Justice from the judges? Administration. Otherwise, the Chief Justice would be equal among equals.
Okay, but you are saying that because these specific provisions of the Constitution specifically mention Chief Justice, so by analogy, he has other powers as well. That's what I've understood from your
Yes,
argument.
by analogy,
ठीक,
he is
then-
the senior among equals.
Okay.
And you see where there is a power under 191 to frame rules, the rules are for the purposes, administrative purposes. And in addition to the rules, there are constitutional or there are conventions of the court which have invariably been followed since since the 1956 Constitution and before that the Government of India Act. So those conventions have also acquired the place of rules or, for that matter, the procedure of the court.
Yes, my lord, Article 268(7) is very much clear to that extent that anything having the force of law has been deemed as law, my lord.
268(7).
268(7), my lord. Now, what this law has done, the law does not say that the Chief Justice, in consultation with the two senior judges, shall constitute a bench. No. Had it been so, it would be least objectionable. What has been done, my lord, that any two of the three may constitute a bench. So the office of the Chief Justice has been converted into that of a senior judge, or the positions of the senior two judges have been converted into quasi-chief justices. This is my submission, my lord. There is no consultation. While concluding the arguments on the previous hearing, your lordship mentioned to the preamble, Article 2, Article 2A, 227, and I'm grateful that your lordship referred to the Grun norm. No consultation is there in this law, my lord. No consultation. And one potential deadlock which I see, not today, say 50 years from now, my lord. The two judges on one side, the Chief Justice on the other side, 50 years from now. The two decide.
Why 50 years from now? Why
My
not
lord,
tomorrow?
Not regarding the incumbent.
चलें आगे बढ़े ना आगे
मैं एक potential.
आप इतना लंबा तमलीग बांध रहे हैं
मैं 5 मिनट में खत्म.
चलिए कह दीजिए
If the two judges are
हाँ ठीक है तो he
on
be in
the
a
one side,
minority, big deal.
and the two decide
So what?
that my honorable the Chief Justice, we have established, we have created a roster, and according to that, for the next month, you will do the chamber work.
ठीक
You will not sit on a bench.
ठीक है
So the office of the Chief Justice has been paralyzed, my lord.
Chief Justice can do so himself.
I'm not saying, my lord. I'm
So
not saying.
it implies that Chief Justice can do so, it's okay.
not saying
But
this.
if two senior judges do so, it's wrong.
My lord, there cannot be
या
any.
तो कहें कि कर ही नहीं सकते हैं तो बात खत्म हो
There
गई.
cannot be any Supreme Court without the Chief Justice. This is my point.
We know that because the Constitution
The
says
Constitution says.
Yes.
And that would tantamount to sending the Chief Justice on forced leave. Such like enactment made by a dictator has already been nullified.
तो इसका मतलब ये हुआ कि अगर चीफ जस्टिस के पास पावर हो और वो कहते हैं कि ये दो जजेस जो है ये अगले 1 महीने तक चैम्बर वर्क करेंगे फिर
My
क्या
lord, अगर कोई deficiency है rules
अगर
में,
में चले तो अगर ये भी हो सकता है
अगर deficiency, I'm not saying, I'm not going to the wisdom of this law. I'm referring to the potential dead end we may go into.
ठीक ठीक
लर्नड काउंसिल आपने
चलिए आगे
अभी
बढ़ें।
तक लर्नड काउंसिल अभी तक आप फ्यूचर का बता रहे हैं एज द लॉ स्टैंड्स टुडे हाउ आर यू इनकन्वीनियंस्ड आपका कौन सा पर्सनल राइट जो है इन्फ्रिंज हुआ है एंड व्हाट फंडामेंटल राइट आर यू ट्राइंग टू इन्फोर्स बिफोर अस
That question goes to the maintainability of the petition, my lord. And except for 3, all fundamental rights are subject to law, subject to reasonable restriction imposed by law.
आपसे सिंपल ये
उसी पे आ रहा हूँ, my lord.
either say yes or no are you inconvenienced by this law
Yes.
has any fundamental right of yours has it been infringed
Yes,
and
my
please
lord.
kindly tell us what fundamental right are you trying to enforce
Yes, my lord. I'm referring to that.
you don't want
I have the
you
prime
don't want
right.
access to justice to be
No.
कुछ और infringement बता रहे हैं मुझे बताइए
Yes, my lord. All fundamental rights except for the dignity of man and forced labor and slavery, all have been subjected to law. Now the law means
dignity of
validly
the Chief
passed
Justice.
law, validly passed law coming from a competent legislature, that I may not be subjected to a law for which the respective legislature is not competent. This is all fundamental rights are involved, my lord. And the mother of fundamental rights, Article 4,
नहीं ये infringement का बताइए ना कौन सा fundamental right infringe हुआ
my lord, if the law is maintained without the necessary legislative competence, it means I'm subjected to a law for which the parliament was not competent. So it is going to affect every fundamental right.
ठीक और कोई point?
Now, furthermore, under the constitution, all judges are equal, my lord.
जब कह चुके हैं
नहीं आगे बढ़े ना
मैं आगे बढ़ता हूँ.
अब हमें कोई लेक्चर ना दीजिए जो लॉ स्कूल में देना चाहिए प्लीज
ठीक है, मैं अपील पे बहुत कुछ कहा जा चुका. मैं सिर्फ एक potential misuse, एक potential. My lord, under the impugned act, the committee of 3 judges may themselves sit in a bench constituted under Article 184(3). Now the judgment comes, and there is an appeal stage. Now the same committee will decide as to who should hear the appeal against our judgment.
So what's wrong with that?
My lord, it amounts to appealing unto Caesar against Caesar. There is a potential conflict of interest. If I would have been a judge, I would have an interest that my judgment is preserved.
When you become a judge, we can look into it.
No. So this,
Bas?
and my lord, मैं दो points करता हूँ. As per section 77 of the Act, which says that every case having urgency or where there is a prayer for interim relief shall be fixed within 14 days. Hardly there would be a case in which there is no prayer for interim relief. So
There will be what?
in which there is no prayer for interim relief. Almost every case has a
I think
prayer.
you're mixing up the concept of interim relief with urgency.
The word interim relief has also been used.
ठीक है, okay. So
May I read
we
one
can apply a brain, which we do occasionally.
Okay.
And we can determine what is
what
urgent and what is not urgent. So what's the big deal about?
What is objectionable? What is objectionable? That the affairs of the apex court have been micromanaged. Even the civil court ordinance, even the CPC doesn't micromanage the affairs of a civil judge. It is in a way contemptuous. It is insulting. Throughout the world, we have phrases like case management, court management. These are the inherent powers. These are always left to the court, let alone the apex court.
Actually, I'll tell you what we did. I've constituted a committee for case management. So I have given my powers already to a case management committee. So you are saying that act of mine is unconstitutional?
No, my
Because
lord.
only I can do it myself, or the full court can do it.
No, my lord. It is for this honorable court to do case management. Whoever is delegated that function,
ठीक.
it is. But the law cannot micromanage those affairs.
Okay. Chaliye, next point.
Now,
Your point is that by enacting this law, a power of micromanagement has been conferred on the parliament, which would open the door for it to micromanage not only these things, but subsequently any other thing that it needs to interfere with.
yes, my
And
lord.
that would affect the separation of powers and the independence of the judiciary.
Yes, my lord. And in legal philosophy, it is called the slippery slope theory.
Sorry?
Slippery slope.
Slippery
theory.
slope.
Yes, my lords. Once you are on a slippery
चलिए
slope.
आगे बढ़ें.
Now, concluding my
Learned Counsel, there was a judgment from the Peshawar High Court regarding the internment centers. For the last 4 years, that petition is pending before this court. And the Chief Justice felt, many Chief Justices, that that was not an important case enough to be fixed before the court. So you justify that? You
My lord,
justify the exercise of such power?
I'm
And
affecting.
that the parliament is bereft of jurisdiction not to come to the rescue and ensure access to justice by merely regulating a discretion of the Chief Justice?
My lord,
Do you defend that, justify that?
I am the effectee of that case. I'm a petitioner. I'm
Are
a
you
counsel in that
justifying-
case, my lord.
Are you justifying it?
That again goes to the wisdom of this law. Wisdom is always with
If you are an effectee of that case and I tell you I will never fix that case, what will you do?
that would, if
No, to answer the question.
वही answer कर रहा हूँ.
If, nahin, I'm telling you, I'm saying it, I'll give you an exact
that
proposition.
would tantamount to violating the Constitution. Article 37,
What is your remedy?
37 says,
What is your remedy?
my lord, Article
None.
37 says that there
We
should
know
be
what article
inexpensive
says.
and expeditious justice.
So what is your remedy?
that is
Nothing.
tantamount to breaching the oath.
Yes, what is your remedy? File a reference against me.
So my lord, if
Then what will you do? Tell me.
I'll file early hearing applications.
Oh, I'm
And-
dismissed.
and-
Mehboob,
and
that I
if-
dismiss.
And if it,
And then I dismiss, then what will you do?
If at all it was expedient, the constitution should have been amended. Article 55A, for instance, should have been inserted.
Okay.
Titled Practice and Procedures of the Supreme Court.
Okay.
My final submission, my lord, as I said that your lordship referred to the supreme law, the Quran and Sunnah. Now, consultation is a good thing. Nothing has restrained the Chief Justice from consulting his colleagues. But this law doesn't have a single word regarding consultation. And another thing, I can proclaim with pride that those were the Muslims who introduced the office of the Chief Justice. Imam Abu Yusuf was the first Chief Justice of human history. And he was not the appellate court.
Why was he the first Chief Justice? Do you know the story? That you don't know.
I don't know the story.
Yes, because the person who was nominated did not want to become Chief Justice. ये भी बताएं ना फिर, और उनको कोड़े खाना पड़े कि बनना नहीं चाहते थे।
Yes.
मैं इस काबिल नहीं हूँ।
Yes.
उनसे कहा गया आप झूठ बोलते हैं कि आप झूठे को चीफ जस्टिस बनाएंगे।
Yes.
वैसे आप बात ना करें, मगर मुझे इस्लामी तारीख में ये बता दें कि एक अपील का हक नहीं है। कोई ऐसा कानून है या शरई असूल है कि अपील का हक एक दफा काजी ने फैसला कर दिया आखिर है कि अपील का कोई हक नहीं है। ऑफिस ऑफ चीफ जस्टिस बनने का मकसद ये होगा कि अपील का हक है।
He was the administrative head
भाई
of all
अपील
the
के हक की बात कर रहा हूँ, अपील के हक की बात कर रहा हूँ।
अपील के हक में my lord प्रो एंड कॉन्ट्रा आ रहा है।
प्रो बता दें मुझे, एक कौन बता दें?
अल इज्तिहाद ला यनक़दु बि इज्तिहादिन आखिर। Once an analogy is made that cannot be set aside by another analogy. So वो है
बात अलग है, वो लोअर और ऊपर फोरम की बात होती है ना। उसमें भी इस्लामिक जूरिस्प्रूडेंस, इस्लामिक शरिया में there were tiers of courts.
But the Qazi al-Qudah, he was the administrative head of the whole judiciary of the time.
जी आप कोई रेफरेंस कहेंगे बस आपने कह दी।
That is without any
किताब का हवाला देना फरमाएंगे या नहीं?
डॉक्टर गाजी साहब अदब
भाई आप कोई किताब देना हवाला देंगे या बस ऐसे ही कह दिया?
डॉक्टर महमूद अहमद खाजी साहब की किताब है,
हमें किताब दिखाइए।
अदबुल काजी
दीजिए।
मैं दूंगा मेरा।
कब देंगे?
मैं जनाब को दिस इज एकेडमिक क्वेश्चन।
नहीं, एकेडमिक अमेरिका के लिए तो एकेडमिक नहीं है, न्यूज़ जर्सी के केसेस को। मगर हम अपनी बारी का इस्लाम की बात करते हैं तो फिर एकेडमिक हो जाता है।
एकेडमिक नहीं, मैंने तो
बताते ही नहीं, फिर आप रेफरेंस दें ना, फिर हम लिखें, नोट करेंगे ना।
अदबुल काजी महमूद अहमद, डॉक्टर महमूद अहमद गाजी, माय लॉर्ड। सो विद दिस सबमिशंस इन नटशेल,
चलें, थैंक यू,
आई एम ग्रेटफुल सर।
कोई रह गया इस तरफ? और आपको सुना नहीं था पहले?
नहीं, बिल्कुल नहीं।
आप वकील हैं या खुद हैं पिटिशनर?
इन पर्सन
जी,
इन पर्सन
जी।
आपकी पिटिशन का टाइटल क्या है?
योर कॉन्स्टिट्यूशन पिटिशन नंबर 18 मोहम्मद शाहिदान एडवोकेट वर्सेस फेडरेशन ऑफ पाकिस्तान।
ओके,
18 ये मैंने अर्ज भी किया था, ये 2 पेजेस पे उर्दू में है।
आपने तो कहा था पढ़ लीजिएगा, मुझे और कुछ नहीं कहना।
नहीं, मैंने नहीं कहा।
अच्छा, वो किसी और ने कहा था, ठीक है। हाँ, वो वर्दक साहब ने कहा था, ठीक। 18 नंबर, जी फरमाइए।
योर ऑनर, ये जो अपील के ऊपर ही आ जाते हैं ज़्यादा, जो फोकस किया हुआ है अपील को। अपील किसी भी हायरार्की में, आप सेशन कोर्ट से लेके हाई कोर्ट, सुप्रीम कोर्ट, कहीं पर भी देख लें, किसी को हक नहीं दिया गया है कि एक कोर्ट के अंदर ही अपील हो, सिवाय ये वो जो लॉ रिफॉर्म ऑर्डिनेंस में आर्टिकल 199 में अपील का राइट दिया, बाकी किसी जगह पर नहीं दिया गया। एक बात और
वो लॉ रिफॉर्म ऑर्डिनेंस गलत है।
यूरान में आज
कब कंक्लूड तो करें ना बात को।
कंक्लूड करता हूँ जनाब, मैं लेकिन मैं साथ में ये भी साथ में एक लफ्ज़
पहले बताएं वो गलत कानून है, गैर आईनी है, बता दें, कह दें या कहें कि ठीक है।
चलें यूरान में इसी की एक और फर्दर बात करता हूँ।
फर्दर ना कहें, जब देखें ऐसे आर्गुमेंट नहीं करें ना,
मैं
इसी बात करें, पूरी बात कर लो।
लेकिन जो इसमें अपील होती है वो सेम जजेस के पास नहीं होती। अगर किसी ने फैसला किया है तो वो दूसरे जजेस के पास जाता है।
यकीनन हजूर, इसमें तो कोई दो राय नहीं हो सकती
अभी
ना।
जो आप लास्ट में वो बात कर रहे थे कि अगर 15 जजेस फैसला देते हैं तो फिर अपील किसके पास जाएगी?
नहीं होगी किसी के पास, अल्लाह ताला के पास होगी फिर।
यही बात है ना,
कभी तो खत्म होगी ना बात।
बिल्कुल, ये होनी चाहिए। देखें जी, ये इस कोर्ट से एक्सपेक्ट किया जाता है कि दिस इज द एपेक्स कोर्ट ऑफ द कंट्री।
अच्छा, सरदार साहब कह रहे हैं कंटेम्प्ट ऑफ कोर्ट में भी अपील है, वो भी तो उसी अदालत में।
कंटेम्प्ट ऑफ कोर्ट में जो अच्छा चले,
और इस अदालत का फैसला है वो जो कम जजेस ने क्या बताया ना, क्या
इंट्रा कोर्ट अपील है वकील साहब, सिंध में भी है, ये सिंध हाई कोर्ट में भी है। इधर देखिए
जी,
1980 सिविल कोर्ट अमेंडमेंट के तहत इंट्रा कोर्ट अपील सिंध हाई कोर्ट में भी है। सिंगल जज के फैसले के खिलाफ टीबी में अपील होती है, हाई कोर्ट अपील कहलाती है वो। लाहौर में, इस्लामाबाद में आईसी है इंट्रा कोर्ट अपील, बिल्कुल अंडर द लॉ रिफॉर्म्स ऑर्डिनेंस 1972।
उसी की
वो जज थोड़ी सुनता है जिसने ओरिजिनल फैसला किया होता है, वो तो डीबी बनेगी, सिंगल का फैसला डीबी में जाएगा अपील में।
सेम जजेस के पास नहीं जाता है। आईसी में जजेस डिफरेंट हो जाते हैं,
जाहिर है डिफरेंट होंगे ना, तो यहाँ भी डिफरेंट होंगे ना।
ये एक तो ये हडल
अगर यहाँ पे 184(3) में 3 जजों ने डिसाइड किया है और राइट ऑफ अपील दी गई है, तो वो 3 थोड़ी बैठेंगे उसमें सुनने के लिए।
रिव्यू में वही सुनेंगे, अपील में कोई और सुनेगा। ये तो ये आप चाहते हैं हम, तो ये तो हम तशरीह कर देंगे, तो ऑब्वियस सी बात है।
बिल्कुल बिल्कुल, इसकी तशरीह भी होनी चाहिए।
अच्छा ठीक है, और क्या पॉइंट है आपका?
अच्छा योर ऑनर, तमाम अपीलें जो हैं जो इस कोर्ट में होती हैं, जिनकी चीज़ तमाम अपीलें जो इस कोर्ट में होती हैं, ट्रिब्यूनल की अपीलें 212 में या जो भी कंटेम्प्ट में होती हैं, वो तमाम अपीलें जो हैं 185 के साथ होती हैं। 185 के अलहदा नहीं होती, उसमें टाइटल 185 होता है रेड विद। तो क्या 184 को भी 185 में हम लाएंगे?
अब सवाल पूछेंगे, हम जवाब अपना जजमेंट में आपको जवाब दे देंगे।
ये बिल्कुल
ये
मैंने रेज कर दिया ना जनाब, मैंने एक आईनी सवाल रेज कर दिया ना।
ठीक है, हम जवाब दे देंगे आपको।
आज तक जितनी अपीलें हुई है ना सुप्रीम कोर्ट में, मैंने वो उसका पता करके आया हूँ कि वो मैं AOR से भी पता किया कि वो 185 में ही आती हैं, चाहे वो
ठीक।
तो आप कहना क्या चाहते हैं कि आप कहते हैं कि उनको तो अपील की रेमेडी है, क्या 184 में होनी चाहिए या नहीं होनी चाहिए, या 184
मैं ये कहना चाहता हूँ कि अगर देखें ना 212 जो एक आर्टिकल है,
उसमें अपील है, इसके बारे में क्या कहते हैं?
उसमें अपील है, तो इसमें क्यों नहीं दी गई? फिर 184 में क्यों नहीं दी? जिन्होंने देखिए ये जो आइन बनाया है, ये कॉन्स्टिट्यूएंट असेंबली ने
आप जवाब सुनना चाहते हैं, जरा जवाब लंबा हो जाएगा
जी।
फिर अगर ये जवाब आपको शायद पसंद ही नहीं आए,
नहीं मैं उसके लिए भी तैयार हूँ।
अच्छा सुन लीजिए फिर।
हाँ,
ये इशू कभी पहले क्यों नहीं राइज हुआ? 73 का आइन है ना
योर ऑनर,
184 का इख्तियार, 184(3) का जो इख्तियार ज्यादा इस्तेमाल किए गए, कब इस्तेमाल किए गए? 73 में, 74 में, 75 में, 76 में, 77 में, कब पहला इख्तियार इस्तेमाल हुआ? वो होता था एक जनरल लोगों की इन्फोर्समेंट ऑफ फंडामेंटल राइट के लिए, ठीक है ना। अब शायद हमने तजावुज़ कर दिया खुद ही 184(3) में से, शायद, या तो आप कहें नहीं किया। आपके सारे जजमेंट 184(3) के बहुत अच्छे हैं, मुफीद हैं, सबके लिए फ़ायदेमंद हैं, वो तो एक बहस होगी। तो जहाँ हम तजावुज़ खुद कर रहे हैं, आपने कहा कर तो दिया तो खैर है, मगर इसका कोई सलूशन भी नहीं है, सिर्फ आइन को आप तरमीम कर लें। आइन में तरमीम करना ऐसा आराम से बात कहना, आप 2/3 अक्सरियत लाइए ना, आप यहाँ करके खड़े होकर के बाहर के इलेक्शन लड़ना एक मुश्किल हो जाता है जीतना। वहाँ 2/3 इलेक्शन लाना कोई आसान काम नहीं होता है कि पार्लियामेंट में जी कर लें, सिर्फ कॉन्स्टिट्यूशन अमेंडमेंट कर लें। तो पहले आप कहें कि जी तजावुज़ तो आपने कर लिया, उस पर तो उसको तो छोड़ो। मैं वो जुमला नहीं इस्तेमाल करना चाहता हूँ जो आम फहम में इस्तेमाल करते हैं, वो तो हो गया, दरगुजर करें, मगर गलती तो कर दी। अब हमारी गलती सिर्फ 2/3 पार्लियामान कर सकती है। 3 जजेस की गलती, यानी कि 400-500 लोग जितने भी हैं पार्लियामेंट में, सेनेट में, दोनों में मिला करके, शायद सूबों वाले भी आ जाए उसमें, वो सिर्फ कर सकते हैं। ये टोटल आर्ग्यूमेंट है या कोई और भी बेहतर आर्ग्यूमेंट है इसके अलावा?
नहीं,
या तो आप कहें कि सारे फैसले 184(3) के दुरुस्त हैं, ये तो फिर मैं आपकी बात मान लेता हूँ, हतमी हो गए, ख़त्म हो गए, छोड़ो आगे बढ़ते हैं, या कहें गलत भी हैं।
योर ऑनर, जो पब्लिक इम्पोर्टेंस का लफ्ज़ इस्तेमाल किया गया है वो 184 में इस्तेमाल किया।
सारे फैसले दुरुस्त हैं या गलत हैं?
मैं उसी फैसलों की बात कर रहा हूँ। पब्लिक इम्पोर्टेंस का फैसला होना चाहिए, मैं यही अर्ज करना चाह रहा हूँ। मुफादे आमा का फैसला होना चाहिए।
जवाब ही नहीं देना चाह रहे हैं।
मैं तो उसका जवाब मुफाद आमा का फैसला होना चाहिए, मुफाद खासा का फैसला नहीं होना चाहिए, खास लोगों के लिए।
जो आप
खास
तो आपने
लोगों
कहा
के
मैंने
लिए
कोई पढ़ा ही नहीं
फैसला
है,
होना
जजमेंट
चाहिए।
रिपोर्टेड जजमेंट जो हैं आपके ख्याल में सारे दुरुस्त हैं? अब इस पे जवाब ही नहीं देना चाहते
मैंने
हैं।
काफी पढ़ी है, काफी हद तक दुरुस्त है, उसको मैं डिफेंड करने के लिए भी तैयार हूँ।
ठीक ठीक, फिर तो ये कह देना
काफी
सारे
हद तक,
दुरुस्त हैं,
बिल्कुल
सारे दुरुस्त हैं, सही है।
अब शायद मेरी नजर से कोई वो जजमेंट ना
ठीक,
गुजरी
ठीक
हो,
है, बस आपका मौकिफ ले रहा हूँ।
यूराना मैंने
हजूर आगे बढ़िए।
मैं ये क्लेम नहीं करता मैंने सारी जजमेंट पढ़ी है,
ठीक है।
जो मैंने पढ़ी है उसके मुताबिक तो मैंने उनको सही समझा है, और वो
तो
इंटरप्रिटेशन जो है।
अगर कल आप बाकी जजमेंट जो आपने नहीं पढ़ी आप पढ़ ले और आप इस नतीजे पे पहुंचे कि वो तो सही नहीं है, फिर क्या होगा?
अगर वो नहीं होगी तो उसमें जनाब रिव्यू का जो कॉन्स्टिट्यूएंट जिन्होंने बनाया है उन्होंने रिव्यू का रखा इसीलिए है कि उसको रिव्यू किया जाए। अब मैं तो जनाब इसमें से वो
आगे बढ़े, दूसरा पॉइंट कोई है आपका?
अच्छा,
फिर हम दूसरे लोगों को सुने ना, बहुत टाइम निकलेगा।
इसमें जनाब मैं वो
कानूनी और आईनी बात करें,
मैं इस्लाम की बात भी करता हूँ। दीन हमारा जो स्टार्ट होता है कुरान
करिए
में,
करिए, हवाले दीजिए।
मैं दीन जहाँ स्टार्ट होता है, जब अल्लाह ताला ने इंसान
हवाले
को
दीजिए।
बनाया, जब अल्लाह ताला ने इंसान को बनाया तो फरिश्तों ने जब इतराज किया तो अल्लाह ताला ने उनका जवाब दलील से दिया और उनसे पूछा कि हाँ भी इनके आप नाम बताएं, तो हजरत आदम अलैहिस्सलाम ने बता दिए और तमाम ने सजदा किया इल्ला इब्लीस।
प्लीज ऐसे तो ना करें ना, कोई हवाला दे किसी बात
तो अल्लाह ये कि उन्होंने भी दलील अल्लाह ताला ने उनके सामने रखी।
यही तो हमारी भी बात है।
तो ये जो जजमेंट्स हैं हमारे फैसले वो भी दलील पे होने चाहिए,
होने चाहिए। अगर नहीं हो
मैं इसी का कि स्टार्ट ही जो अल्लाह ताला ने फरमाया वो दलील से फरमाया है।
सही है, इस पे
उसके अलावा और भी कई इसमें कुरान में हवाले हैं जो दलील पे बात की है। हालांकि अल्लाह ताला फरमा देते कि जी मेरा नॉलेज है, किसने इनकार करना था।
ठीक है,
तो वो जब एक मालिक सारी दुनिया का वो दलील से बात कर रहे हैं तो सबको दलील से बात करनी चाहिए।
ये तो बात अपने खिलाफ आप कर रहे हैं।
नहीं, मैं दलील से बात कर रहा हूँ जनाब।
आपकी बात नहीं कर रहा हूँ, आप कह रहे हैं कि एक दफा फैसला आ गया तो हतमी है, चाहे उसमें दलील हो या ना हो, हतमी है।
योर ऑनर, एक अपील नीचे से आती है, आते आते हम यहाँ तक कितने सालों में, कितनी सदियों में पहुंचते हैं।
फिर आप ये इधर ऐसी डिस्कशन कर रहे हैं, फिर अगले को सुनते हैं ना, कोई
मैं
जनरल बातें ना कीजिए ना प्लीज।
दूसरा जनाब, ये एक तो ये अपील के बारे में जनाब मैंने अर्ज किया,
आगे बढ़िए प्लीज
जी। अच्छा, 184 और 185 दोनों में कहीं सब्जेक्ट टू लॉ और सब्जेक्ट टू कॉन्स्टिट्यूशन नहीं कहा गया।
ठीक,
ना 184 में ये बात है और ना 185 में।
ठीक,
और योर ऑनर, ये जो इन्होंने इख्तियार दिया है कि ये कमेटी बनेगी और कमेटी जो है इसका फैसला करेगी, आइन ये कहता है ये इख्तियार जो चीफ जस्टिस को दिया गया वो पूरी सुप्रीम कोर्ट ने दिया है। रूल्स बनाकर, रूल्स के तहत ये चीफ जस्टिस को इख्तियार दिया गया है। अगर चीफ जस्टिस साहब इस इख्तियार को कर्टेल करना चाहते हैं तो बेहतर होगा कि वो उसी सुप्रीम कोर्ट के पास जाएं, कमेटी में बैठें और वहां पर फैसला करवा लें, दो का जी कि दो करेंगे।
सही है, ठीक। बस अजी, अगर ये यहाँ पढ़ के तैयारी करेंगे तो हम नहीं सुनेंगे। नेक्स्ट, आप ऐसे नहीं होगा ना, आप समझ रहे हैं बस हम कैप्टिव हैं जो
मैं तो बिल्कुल मुख्तसर अर्ज
तो कर दीजिए ना, पढ़ के अब सोच रहे हैं जल्दी जल्दी बताएं ना
जो पॉइंट्स मैंने लिखा है, जो मैं
हम पढ़ लेंगे। अगर आपने इसमें एक लफ्ज लिखा है, इस पूरी एक कागज की आपकी दरखास्त है टोटल
दो सफ़ों की, दो सफ़ों की,
चलिए दो मान लिए।
अच्छा, ये जनाब वो जो ये बार बार ये जो इसका लोकल स्टैंडाई की बात की जा रही, फंडामेंटल राइट्स कंसर्न फ्री जो है, तो इसके बारे में मैं सिर्फ एक लाइन में जवाब देना पसंद करूँगा कि मेरा राइट है कि हर काम कानून और आइन के मुताबिक हो।
चले सुन ली, आइए।
और बेंच पूछना चाहते हैं सवाल तो मैं हाजिर हूँ।
सर, मैं कॉन्स्टिट्यूशनल पिटीशन नंबर 6 में हूँ, न पिटीशनर हूँ न रिस्पॉन्डेंट हूँ, जमात इस्लामी की तरफ से हूँ और सिर्फ नोटिस आया पार्टी को। तो इस
आप अगर आप इसको अपोज कर रहे हैं कानून को, फिर सपोर्ट वाले बाद में सुनेंगे। आप जगह दे दें प्लीज, सपोर्ट वालों को बाद में, सपोर्ट वाले बाद में सुनेंगे अटॉर्नी जनरल के साथ। जी, आप कर चुके हैं, कोई और रह गया? आइए इधर से। कौन नहीं, आप उस दिन चले गए थे. Attorney, please don't interrupt. Attorney General, will you lead the arguments or will you respond to the arguments?
Yes, I will respond, my lord. Mr.
Sir, this is very
Zahid
unfair.
Ibrahim will go
My
first.
lord, the Chief Justice, this is very unfair. आपने कहा था कि अटॉर्नी जनरल साहब को आर्ग्यू करने दें, हम आपको बाद में सुनेंगे. अब आप
दिखाइए, ऑर्डर शीट दिखाइए.
ये दिखाइए. This is very unfair. I will not argue if you don't want to hear me, but don't put things which are factually incorrect.
वैसे अगर कोई बात कर रहे तमीज से कोई हर्ज होता है वैसे?
नहीं सर, आप
सुन लीजिए, आप
अपने असलूब को देखिए.
आप अपना इसमें
आप अपने असलूब को देखिए, फिर आप हमारे मुतालिक बात कीजिए.
देख लेते हैं.
आपका अपना असलूब ठीक नहीं है. ख्वाजा तारिक रहीम साहब ने इसी वास्ते आ जाने से इनकार कर दिया क्योंकि योर लॉर्डशिप वाज very unkind to him.
Please don't argue on behalf of those who are not present.
Sir, he is my colleague. He has instructed me to inform you this.
सुन लीजिए, ये सब जजेस ने साइन किया है. Mr. Imtiaz Rashid Siddiqui, representing the petitioner in Constitution Petition number 6 of 2023, who was partly heard on the last date of hearing, states that he does not want to add anything further and that his written submissions may be read.
कौन सा order है?
Thank you very much. Now please take your seat.
Mr. Zahid Ibrahim.
I must lodge my protest.
Please
on your
take your
lordship.
seat before I issue something. Please take your seat.
Mr. Zahid Ibrahim, followed by Mr. Salahuddin.
It's as you wish. If you want to go last,
I'll go last, my lord.
as you wish. Everybody who comes, please introduce themselves. Who are they for?
I'm representing PMLQ.
Have you filed anything?
Yes, my lord, I filed CMA 3991 of 23. I'll be very brief, my lord.
3991.
Of 23. My lord, I'll be very brief and to the point.
Take a second, just let us get it out. CMA.
What is CMA number, right, sir?
My lord, 3991. May it please your lordship. We've heard
Do we
various...
need to have it before us or we don't need to have it before
My
us?
lord, if I do, I'll sort of, to a very limited extent, I'll refer to that later. If I may just address, my lord, that we are trying to understand the various meanings hidden within the few articles of the Constitution. In order to do so, the basic rules of interpretation which, according to this honorable court, have been, are to be utilized in reading and understanding these provisions. First, let us just identify that. How are we to read these articles? My lord, the Honorable Supreme Court in the Sui Southern Gas case, 2018 SCMR 802.
802.
802, my lord. The court summarized.
Have you given a paper poke or something with these?
My lord, ये तो judgments.
Judgments.
Judgments की मैंने I'd given the list. I'd given the list in the morning.
Okay.
Yeah, you mentioned it in paragraph 3 of your CMA. In the case of Sui Southern Gas.
My lord, because
you have reproduced.
I want to read the just one sentence from the judgment.
Relevant page?
My lord, relevant page is at 830.
830.
830. What the court did here was it looked at all the case law, it looked at all the treaties from A.K. Broi Saab's to Justice Fazl Karim's to Servai Saab's, and it summarized the rules on how we are to interpret Constitution. And my lord, those rules are summarized on page 830. A through I.
830.
I will not read all of those, but on the next page, 831, the Supreme Court cites with approval a judgment and that is at paragraph 14B. Uska ek, I mean, that sentence really encapsulates how we are to read these provisions. My Lord, paragraph 14B. It's a Indian Supreme Court case which has been cited, and it says, the cardinal rule of interpretation, however, is that words should be read in their ordinary, natural, and grammatical meaning subject to a rider. First rule is cardinal, ordinary, natural, grammatical meaning, subject to this rider. My Lord, I'm reading from 14B, paragraph 14B. Subject to a rider. That in construing words in a constitutional enactment, conferring legislative power, the most liberal construction should be put upon the words so that the same may have their effect in the widest amplitude. This is the basis on which we are to interpret these provisions of the Constitution. My Lord, with regard to entries,
Mr. Ibrahim, this principle is applicable in all eventualities?
my Lord, that is what this judgment says. And I'm just setting out the basic rule that the Supreme Court has set out. And then, my Lord, at page 838,
there is absolutely no departure from this?
No, obviously, my Lord, we make departures when we are reading and in trying to interpret. But a basic rule is set out. First of all, you determine what are the rules of the game on how do we read these provisions. And one of the rules that it says...
You see the situation which has arisen out of the proceedings which have been going on, whether this en bloc interpretation is applicable?
In my view, yes.
This, how come?
In my view, yes. And I'll come to that. My Lord, on page 838, entries of the legislative lists on how they are to be read are also, the rules on that have been summarized. And if we see 838, the rule set out in paragraph 2, in construing the words in an entry conferring legislative power on a legislative authority, the most liberal construction should be put upon the words. 3, while interpreting an entry in the legislative list, it should be given widest possible meaning and should not be read in a narrow or restricted sense. 4, each general word in an entry should be considered to extend to all ancillary or subsidiary matters which can fairly and reasonably said to be comprehended in it. My Lord, if we read these provisions, now coming to the matter at hand, my reading in relation to the practice and procedure part of this law, I'm not referring to the appeal part, the practice and procedure part. My Lord, the legislative competence, in my view, arises from Article 142A, where the Parliament can make exclusive power to make laws in respect of matters in the legislative list, federal legislative list. From Article 142, I look at the federal legislative list and I look at entry 58. Entry 58, matters which under the Constitution are within the legislative competence of the Parliament or relate to the Federation. Matters which under the Constitution are within the legislative competence of Parliament.
You see, if you
what are the matters?
go by that argument, then there is no need for any other entry in the legislative list. Just this one article, this one entry would cover everything.
With, if I may answer your Lordship's question, that does this provide then complete free hand? No. It is only to the extent, the language is very clear, sir, and it's not all encompassing. It says matters which under the Constitution are within the legislative competence of Parliament. What is within the legislative competence of Parliament? Article 191, and this is where subject to law comes in, and the reading of that provision. So what I'm doing is,
what do you mean by, Mr. Zahid?
My lord.
Entry number 55 is not applicable here.
No, entry number 55 is also. Because, and I'll come to that. Because entry number 55.
The legislation has been made in both entries.
In both. Yes. Yes. And I'll come to that.
Mr. Zahid Ibrahim, what is then your argument in relation to the judgments which have been cited?
Yes.
That subject to the Constitution and subject to the law as mentioned in Article 191 is a restrictive provision. It is not a provision which confers jurisdiction or confers powers. It restricts. What's your response to that?
Can you please do respond to the queries, but can you just complete your thought, because my pen has been left in the air. I don't know what you're going to say next. Suspense is killing me.
Your Lordship's observation.
Respond to them.
Because I will respond to it because I have, I will refer to Justice Anwar Bhinder's case and try to express my view on this for your Lordship's consideration. So what I was saying is that in 142, entry 58, entry 55, and then you look at Article 191, where subject to the Constitution and law, Supreme Court may make rules regulating the practice and procedure of the court. Now, the argument being made by those who are challenging this law are saying that once the Supreme Court has made rules, then the door closes. Then there is no subject to law. You cannot do this. My submission to this Honorable Court on that will be that this court, in Justice Anwar Bhinder's case, has said the opposite. In Justice Anwar Bhinder's case, where it was looking at Article 188 there, the power to review. What did Justice Anwar Bhinder's case hold? My lord, this is PLD 2010, Supreme Court 483.
Which paragraph do you...
My lord, there are two paragraphs in this, my lord. First, I would like to refer to page 523, 522 and 523. My lord, paragraph 25. After reproducing Article 188 of the Constitution, where Supreme Court has been given the power subject to provisions of any act and of any rules made by the Supreme Court to review any judgment pronounced or any order made by it. Paragraph 25 says, a bare perusal would reveal that it has been couched in a very simple and plain language, hardly necessitating any scholarly interpretation. It inter alia provides that the Supreme Court has power to review its judgment or order subject to the provisions of any act of Parliament and any rule made by the Supreme Court itself. The contention whether the Supreme Court rules are subservient to the Constitution have been discussed in a later part of this judgment. Now this, my lord, the next sentence is critical. Critical. It says, it is to be noted that no act of Parliament whatsoever has been promulgated and thus it can reasonably be inferred that legislator does not want to restrict or impose any condition on the powers conferred upon this court under Article 188 of the Constitution. In fact, the words subject to provisions of any act of Majlis Shura and any rules made by the Supreme Court are indicative of the fact that indirectly the powers so conferred have been enhanced and there was absolutely no intention for curtailment of such powers conferred upon this court under Article 188 of the Constitution.
This is what it is being said, that because you see, if you read on in paras 36, 37, the discussion is that even the power of the court is to enhance the power. It's not to curtail it.
My lord,
you can't just read one sentence out of it.
But at least one sentence we have to read also.
you can't read one sentence when the context is provided by the immediately following sentence. How can we read a judgment?
I'm not seeking that.
आप आगे जाके पैरा 36 तो पढ़े ना, 36, 35, 36,
सर मैं पैरा 36 भी पढ़ लूंगा. मेरा सिर्फ ये कहना है कि जब सुप्रीम कोर्ट ये कह रही है,
एक जुमले से तो बात
नहीं जरूर मैं
let me come back to
आप अपना आर्गुमेंट तो कंप्लीट कीजिए ना.
आर्गुमेंट प्लीज कंप्लीट करें.
Entry 58.
आपका आर्गुमेंट है क्या? मैं नोट करूं.
Let me come back to entry 58 first. आप कह रहे हैं कि matters under the constitution are which are within the legislative competence of Majlis Shura Parliament or relate to the Federation.
My lord.
This should be given the broadest possible meaning.
Yes.
And you relate this to the rules, well-settled rules of interpretation that you have already read out.
Yes.
And you relate this back now to law.
Yes.
As my learned colleague has already said, that this begs the question whether that is an enabling power. But my question is slightly different.
My lord.
जो rules of interpretation जो आप जिनका जिक्र कर रहे हैं और जिन judgments का आप जिक्र कर रहे हैं, as far as I am aware, those are concerned where the grant of legislative competence was by the entry itself. Okay? The grant was, that is the context in which those judgments are given. Okay? Now, as you are aware, an exclusive legislative list, whether federation or even the provinces, 35 Act, 56 Act, we don't need to go into that. An exclusive legislative list, especially now in the context of 73 Constitution as it presently stands, has two effects. One is positive. The legislative entry confers a power, a legislative competence, but the other is negative. The negative is that it excludes the other legislatures from making any such law. So if you look at it and interpret it in the broadest possible terms, which is the correct way to interpret these entries, it has two effects. It describes constitutionally what is the scope of the legislative grant that is being conferred positively. Negatively, it excludes the other. I put it to you that if 58, which does not itself confer any legislative competence, the effect and purpose of this is not positive, but really negative. To clarify, to put it in the absolute clearest possible terms, that whatever power, legislative power, is given not in these entries, no, in the Constitution itself. Article 151, Article this, that, the number of judges of the Supreme Court, so many other examples can be given. That has, Article 58 is making clear, no intrusion by the provinces, none whatsoever. This is an exclusive grant to Parliament. So therefore, and I put it to you, that the way you are looking at it, it seems to me, with all due respect, and relying on those principles of interpretation, is perhaps not correct, because this is not a grant of legislative competence. It is merely shielding a grant made elsewhere, outside, other than on the legislative lists.
It is shielding that from any possibility of encroachment by the provincial legislature. So that is its true purpose. What would you say to that?
जाहिद साहब, इससे पहले कि आप यकीनन इनके हमारे मोहतरम दोस्त का जवाब दें सवाल का, मगर मेरा फिर कलम हवा में रह जाता है। आपका अगर मैं एक दफ़ा लिख लूँ आपके पॉइंट क्या है, फिर ज़रा मुझे समझ आएगा, फिर बेहतर आप जवाब भी दे सकेंगे। ज़रा आप अपनी बात कंप्लीट कर लें, फिर जवाब ज़रूर दीजिएगा, नोट कर लीजिए।
So the point I was making that yes, you read this entire judgment together.
Proposition बता दें,
proposition is
अपनी proposition दें, judgments, you know this is the full court. आप अपना view हमें दें, आपका view क्या है?
My lord, मेरा view ये है कि जस्टिस अनवर भिंडर्स केस में सुप्रीम कोर्ट ने ये फैसला किया है 188 को इंटरप्रेट करते हुए कि क्योंकि पार्लियामेंट, जहाँ सब्जेक्ट टू लॉ लिखा है, क्योंकि पार्लियामेंट ने कानून नहीं बनाया है, उसका ये मतलब नहीं है कि रूल्स विल कंटिन्यू टू होल्ड द फील्ड एंड देयर कैन नॉट बी एवर एनी लॉ. माय submission is, my reading of Justice Anwar Binder's case is that this case itself acknowledges that Parliament has not made but can make law. That is my.
Are you saying that the judgment is interpreting legislative competence through subject to law and constitution? So where in the judgment exactly does it say subject to should be read as enabling granting legislative competence?
No, my ladyship, all I am saying is, because justice in this case, again the issue was that there was no law. There was made by Parliament in relation to, for instance, abhi jo review of judgments ka law aaya tha and which has been struck down. All I am saying is that the court, when looking at Article 188 at that time, all it was saying is, listen, there could have been a law, there isn't, but we are not trying to say that there can never be.
But please look at the wording of 188. It's very different from 191.
Exactly.
It doesn't say subject to. एक second जी, आप कह रहे हैं subject to the constitution and the law को हम enabling पढ़ें as a source of legislative competence, and you want us to rely on the Anwar Bhinder case in pursuance of this point, which is reading an article which does not say subject to. It is an article which actually says the Supreme Court shall have power subject to the provisions of any act of Majlis-e-Shura. It is saying that that act of Majlis-e-Shura and of any rules made by the Supreme Court. So there is a difference. This is a question that we've been working our way around, that what's the difference between an act of Majlis-e-Shura and the law. There is a difference. When you read subject to the law as an enabling provision, you bring in that executive action like an ordinance. You bring in that many other forms. So you're saying that the Supreme Court rule-making power becomes subservient to all those sources of law that exist, that the Constitution recognizes as being part of the law. So hence, can you explain through this judgment how that helps your point?
My lord, my ladyship, first of all, when we say law, it certainly includes an act of parliament. And I acknowledge that 188 is different from 191. In 188, in fact, the Supreme Court has been given the power of review. In 191, there is no power. There is only acknowledgement that Supreme Court may make rules.
There is a power.
The language is
given to
different.
The Supreme Court. It's.
My lord, the language is different.
Power conferring article which empowers the Supreme Court to make rules. And then a judgment of this court, again, it's, I think in the NRO judgment, which says rules framed under constitutional powers, i.e. the 1980 Supreme Court rules, stand on a higher pedestal compared to ordinary legislation. What does that mean?
If I may, with utmost respect, I know your lordship in the Ghulam Mohiuddin case recently rendered judgment where the Supreme Court review law was held to be illegal. Your lordship has expressed exactly that point.
No, this is not our expression. That
No,
is a reliance on an earlier judgment of this court, which says this.
My lord, all I was trying to point out that the language of 188 and 191 in granting powers to the Supreme Court uses very different languages.
But you see, even this judgment that you're relying on, this also says that the Supreme Court rules are on a higher pedestal and promulgated on the basis of a mandate given by the Constitution.
Thank
ये भी
you.
exactly यही कह रहा है.
Thank you for pointing out. Let me again, in relation to this judgment also, now clarify what this judgment has actually said and what it is purportedly argued that it has said.
No, argument apart, as Ladyship also pointed out, and as has been mentioned earlier, the judgment that you rely upon in itself lays down this, the ratio of the judgment is that the rule-making power, when exercised, when the rules are framed, then such rules stand on a higher pedestal for the reason that those rules have been framed in exercise of powers granted by the Constitution itself. And the powers granted by the Constitution under 191 are the powers granted by the Constitution to the Supreme Court and not to any other organ of the state.
My lord, if we can just see page 536 of this judgment on this point alone.
Before you come to 536, just one quick question. This sentence that you have read out to us from page 523,
yes,
which you regard as critical, is it your understanding that this is part of the ratio of the judgment?
Yes.
This is para 25 head note K जो है ना आपका इसमें पढ़े नहीं. In fact, the word subject to the provisions of any act उसको define किया इन्होंने.
जी सर मैं
बिंडर वाले केस में.
हाँ मैं एक सेकंड.
जाहिद साहब आप चले आर्गुमेंट तो अपना करें ना.
जी. So I was trying to yes, page 536 of the judgment, my lord, of the same judgment.
Mr. Zahid,
जी पढ़िए.
Paragraph 36 is more relevant.
सर मैं उसी पे आऊँगा सर, अगर एक सेकंड के लिए. ये हायर पेडेस्टल वाली जो बात है, 530 पेज 536 पे फर्स्ट पैराग्राफ. The Supreme Court rules are on a higher pedestal and promulgated on the basis of mandate given by the Constitution itself and not by a government, object whereof was to enhance the power of review as conferred upon the Supreme Court under Article 188 of the Constitution. One more time, just the first part. Supreme Court rules are on a higher pedestal. Higher pedestal than what? ये इसके जो preceding paragraph, preceding page है, अगर हम उस पे जाते हैं,
इसलिए कहा है कि रिव्यू में पावर बढ़ाए में रूल्स ने.
सर इसमें ये
I'm trying to understand, Mr. Zahid Ibrahim. Please, can you complete your thoughts? Take the questions, note them. If you keep responding to every query, I don't know what you're going to say next.
Okay, my lord. All I was the point.
You were on 236 AA.
The point that I'm making is that in this judgment, when the Supreme Court says that the rules are on a higher pedestal because they are made under constitutional sanction, what are they saying? Higher pedestal than what? Higher pedestal than law or something else? They are saying higher pedestal than rules made on the basis of another statute.
No.
And if I may just complete, I will complete.
If you would also read the NRO judgment, this point has further been elaborated by this court by saying once these rules are made, any subsequent legislation we may not follow. And we need not follow.
मेरी सिर्फ आपसे ये गुजारिश है कि यहाँ पे जो conclusion हुआ है full court का, in relation to the Supreme Court rules being on a higher pedestal, that is not on a higher pedestal as compared to any law. And the reason why I say this is evident because this discussion started from page 500.
Can you just complete
page
your thought?
534, page 534 at the bottom of page 534.
Para 37.
Para 37, my lord. Exactly.
So Zahid, para 36 is very important.
चलिए जाहिद साहब प्लीज आर्ग्यू करिए as you want to.
Para 37 का ये I'm just
जाहिद साहब अगर मैं आपसे एक सवाल ऐसा पूछूं जिससे मैंने फैसले ही कर रहा हूं तो आप कहें फिर सवाल ही नहीं बनता है, आप अपना आर्गुमेंट कर लें कंप्लीट, फिर हम आपसे सवाल पूछ लें.
I mean, I honestly feel that today, I mean, I'm trying to answer questions.
ये आप पहले आर्गुमेंट अपना कंप्लीट कर लें ना.
They help in this debate.
जी.
So I was just wanting to read para 37 from the bottom. मतलब जो in Roman font है उससे पहले वाला एक sentence. A line of distinction. In this regard, reference may be made to the case of Federation of Pakistan, Saeed Ahmed, PLD 1974. A line of distinction is to be drawn between statutory rules made by the executive pursuant to an act or an ordinance and statutory rules made by the Supreme Court pursuant to the mandate of Constitution as conferred upon it by Article 188 of the Constitution. ये जो sentence है, my lord,
A line of distinction.
a line of distinction is to be drawn between statutory rules made by the executive pursuant to an act or an ordinance and statutory rules made by the Supreme Court pursuant to the mandate of the Constitution as conferred upon it under Article 188 of the Constitution. That is what is being...
Ajay, can you now go back to 536 AA?
If this line of distinction is drawn, Mr. Zahid Ibrahim, if this line of distinction is drawn,
yes,
that which means that the rules made under 188 are of a different category altogether, then there's no need to say that those rules are at a higher pedestal. Then those rules and rules made which are normally called subordinate legislation fall into two different categories. It seems to me that the passage, that those words that you have just read out from page 536 on a higher pedestal is not vis-a-vis a category that the Supreme Court in the words that you have just read out,
my lord,
say fall into a totally separate and distinct category. And if this is correct, then the higher pedestal can surely be only vis-a-vis law and not subordinate legislation or rule-making power, which is of a totally different nature. Would that not be a proper reading of the judgment as a whole?
Perhaps, like the first sentence of paragraph 37, in fact, perhaps answers what your lordship is saying. Supreme Court itself says, in view of the above discussed principles of interpretation, it seems immaterial to discuss whether the Supreme Court rules are subservient to Article 188 of the Constitution. They say that is an immaterial argument. Where it draws a comparison and says that they are on a higher pedestal, that is only in relation to rules made under some other statute. That is the point. My lord,
and if we go back to 536 AA, now if we are to read this line disjunctively, object whereof was to enhance the power of review as conferred upon Supreme Court under Article 188 of the Constitution, then if we are going to read it like the petitioners want us to read it, that would mean that the Supreme Court is not bound by Article 188 either, because it's giving it more power than the Constitution itself. Surely that cannot be the case. So it has to be read in context to the line that you read. I don't know.
I understand that, we are all pressed for time. I don't want to sort of...
हम पढ़ लेंगे पूरा judgment.
My lord, the next point I want to make is in relation to the appeal.
But before you go to appeal, what do you say about entry 58 on which you rely upon? That entry 58 is, since it is not conferring legislative competence, the rules that you rely upon, rules of interpretation, the purpose of entry 58 is the negative aspect of those rules, to make sure that a competence given elsewhere other than the lists, that is totally outside the scope and power of provincial legislature. That's all that the purpose of 58 is. It does not confer legislative competence, and therefore the principles that you rely upon really don't apply. What would you say to that?
Malad, my response to that would be that
ये जाहिद साहब बहुत अच्छा सवाल है. Shall we take the break now, and you have received a number of queries, just mull them over, and then you just be precise in your answers, because we will hear you, don't worry. So we can take a slightly longish, make it this lunch break as opposed to 1:30 and the prayer break or whatever you want to make it. Just make these questions are very valuable for food for thought, and then mull them over and respond to us.
I promise.
We will just come back in half an hour. Is that all right?
I promise to continue, but I can't promise to be able to have all the answers to the questions posed.
You've seen what's been happening these last
Yes.
You should be ready for that.
I've tried, my lord.
आप लोग भी जरा रेपिटेशन ना कीजिएगा, कोशिश कीजिएगा, नए नए बातें कीजिएगा जो इन्होंने नहीं की हैं. चलें, ऐसा होगा.